So I've been asked to speak a little bit about practical advice for activists engaged in undercover covert investigations. I was going to start by recommending bolt croppers, but apparently they want this from a more of a legal perspective. So what I'd like to do is, because it's quite a complex area, but to give you some topics that you need to be aware of and, things that you need to consider. And I'll look at three sort of areas. First of all, how to protect yourself and what risks you may face. Also, people you involve in these sorts of investigations, what are the potential risks to those? And then the key point, which is, once you've obtained this material, what do you do with it? If you're just trying to get the publicity out there, that's one aspect, but what if you want this to be taken further? You want to refer this either to a relevant authority to bring a prosecution, or you even fancy a private prosecution yourself. How do you ensure that any material you gather is actually admissible in evidence? So just to start with, obtaining the materials. Obviously, by definition, this is undercover investigations. You're going to be going into places and filming and recording. How do you get in there? Well, you may get in there yourself, or you may rely on whistleblowers. But if you're going in there yourself, what do you need to be concerned about? Well, how do you get in? Two main ways. You can either sneak in, or some people have obtained jobs in premises like, slaughterhouses and farms. What if you sort of sneak in? Well, trespass per se is not an offence in this country. You would be a trespasser because you would be there without permission. But trespass itself isn't a criminal offence. However, aggravated trespass is. And what's aggravated trespass? Aggravated trespass is where you enter some premises or some property or some land as a trespasser, or land adjacent to somewhere with the intention of disrupting a lawful activity. Now, of course, ultimately, you probably do want to stop this. So are you actually interfering and obstructing a lawful activity? Well, no, so you're merely highlighting things that are going wrong. And if that causes them to be prosecuted or puts pressure, that probably doesn't cross the line. It's more sort of obstructing the lawful activity. But one thing to remember is it's an activity that is lawful per se. It doesn't matter if that activity is being carried out illegally. So just to amplify on that, and I'll give a classic example is quotes, drag hunts and trail hunts. Drag hunts and trail hunts are actually legal in this country, but we all know that a lot of the time people breach the rules, and in effect they are sort of backdoor actual proper hunts. So if you were to disrupt that, are you disrupting a lawful activity or an illegal activity? And it's always a matter of a finding of fact, but the threshold is that if they can say, well, this is a lawful activity, trail hunting, the mere fact we're carrying this out in an illegal fashion doesn't necessarily give you a defence to aggravated trespass. If, however, it was clear that this was just a fox hunt, for instance, that would be illegal. But it'd be a matter of fact as to, you'd have to show the intent was, well, whatever we've labelled it as, we're actually carrying out an unlawful activity. So that's something to be aware of. What if you apply for a job? And you just sort of, go along and say, I'd like to work here. Well, you have to be careful about what you say. I mean, obviously, going in there, they're not expecting you to go in and film, and there's probably all sorts of things in your terms and conditions. I mean, we don't have official ag-gag laws in this country, but we certainly have a lot of private law that can have the same effect. So, there's probably something in there about sort of a confidentiality and not recording or not releasing or not discussing what happens at work. So you would be in breach of contract, but so what? They sack you. However, if you're in breach of contract, they can actually also go for damages. So if they can show your breach of contract somehow got them closed down, they probably could argue about this. Now, as a matter of law, you'd probably say you'd be able to show that actually what you did didn't cause them the loss. It was too remote, because the mere fact you exposed wrongdoing that lost them contracts or something. But when I'm talking about the practical law, I don't want to talk about just what the black letter law says. I want to talk about how the law works in practice. And we get a lot of what we call SLAPs, strategic litigation against public participation. Normally we talk about that in terms of defamation, but it's not just threats of defamation, but I will come on to those. It's using threats of legal proceedings to silence people, because even if you are in the right and you have a defence, legal proceedings are very, very expensive, and they're very, very time consuming, and they're very, very traumatic. I mean, I'm old enough to remember all the McLibel stuff. I mean, and now as that's coming out, we find out the undercover police officer actually wrote the, offending leaflets. It throws up all sorts of issues. But this is what people will do. They will use the threats of legal proceedings. And they'll just try to wear people down, because a lot of these organisations are very, very well resourced. Also, if you were to lie in an interview, because of course you will be receiving a salary, so there is an argument there that by lying in your interview or your application, you have obtained a pecuniary advantage by deception. Because say we wouldn't have actually paid you these wages had we known the truth. So that is a criminal offence. The chances of being prosecuted for that are quite low, but it is something you need to be aware of. So that's the two main aspects as to, if you're going in, be aware of aggravated trespass. Also, be very careful about criminal damage. Obviously, that could be, if you were to sort of, even just like cutting a string on a gate, there's no sort of what we call de minimis principle in criminal damage. I mean, people have been done for just stickers, even though they peel off, but they leave a little bit of residue, or people throwing paint on things that will actually rinse away in the rain. I mean, even things like just chalking on pavements, people have argued that that's criminal damage. So you have to be very, very careful that you don't deliberately or accidentally damage something, so you climb over a fence and you break something. Well, the argument there is that that's criminal damage. So you are exposing yourself to potential criminal penalties. What about if it's whistleblowers? Whistleblowers do have protection. There's something called the Public Interest Disclosure Act that protects people from adverse treatment, such as disciplinary proceedings at work, or being, all that sort of thing. If they make a disclosure, and as the name suggests, in the public interest. But there's a couple of limbs there. First of all, the disclosure has to be in the public interest. And I think exposing sort of, wrongdoing and animal cruelty and animal abuse, that would actually cross that threshold. But then it's how do you make the disclosure and who do you make it to? You've always got defence, for instance, you're always allowed to disclose to your MP or any sort of government official. You can also disclose to the relevant authorities. But here, you're either going to publish this yourself or you're going to pass it on to newspapers and other media outlets. And the argument there might be that actually you should have first reported it to the relevant authorities and not gone straight to the press, because that can lose you the protection. So again, that's something that you need to consider. But let's assume we've got over all that. You're inside and you're doing all your filming. How do you ensure that, first of all, you need to protect yourself against, if you're going to publish this yourself, you need to protect yourself against defamation proceedings. Now, I do a lot of defence side defamation, including lots of animal rights related stuff. And it's really, really common that somebody will do a big expose, people will lose contracts, and then they'll say, well, actually, this is all lies, and we are bringing proceedings for defamation, just to keep onto the contracts pending this happening. Now, there are lots of defences to defamation. I mean, truth is an absolute defence. You just say, well, everything we have out there is true. But you've got to be very careful when you comment on things. If you're actually showing footage, you're always in a much better position than if you just give, like, your opinion without actually showing the footage. Because when it comes to defamation, we have all these ideas of things called like bane and antidote. So you can say something that appears defamatory, but then when people see the whole story, as long as they could make up their own view of it and say, well, actually, now I've seen the whole story, I can see that what they said is true, or I can see what they said is, an opinion. But be very, very careful. Make sure you also link back to the original material. That gives you lots of protections, because there are other defences. You've got the defence of opinion. For an opinion to not be defamatory, first of all, it has to actually be an opinion, not a statement of fact. you have to identify the facts upon which you base that opinion. And that's what I'm coming back to. If you just did an interview and said, we saw terrible, horrible things, and this particular company, they're completely abusing animals and they're completely corrupt and they shouldn't be allowed to do this, but people can't see the original footage, that becomes a statement of fact if you're not careful. Whereas if you link back and identify and say, based on this material, and you don't have to give sort of chapter and verse on it, but you could say, here's some clips, and based on these clips, which are representative of what we saw, we formed the opinion that these people, were behaving badly. But also, it has to be an opinion that a reasonable person could hold. It doesn't have to be an opinion that everybody would agree with. It just has to be an opinion that a reasonable person could come to based on, the actual factual situation. So a lot of the time that won't be too problematic, but be very careful about speculating about motive and things like this, because you'll get people going, we never knew this happened. So if you're saying the bosses allowed all this and they encourage it, and they say, we didn't know about this, we've franchised now, we've got all our sort of appropriate approvals from relevant authorities, how are we to know? Be very careful about that. And I'll come on to how you can protect yourself against that. Also, there's the public interest defence. It's a two-part test though, and a lot of people get this wrong. You have to show, first of all, it was in the public interest that this subject is in the public interest to discuss, and obviously animal abuse and cruelty is. But there's also, was it in the public interest in the way that you actually disclosed this information? And it ties back a little bit to like we were saying before. But it always covers yourself. Give people a chance to respond. Go back and say, we have found this material. What do you say about it? What's your comment? And report on what they said, because this gives you added protection, because then you can say it was in the public interest. Because they'll say, well, why didn't you just report this to the authorities? It's like, well, no, we wanted to expose this, but we have given people a chance to explain and to put their side across. And so long as you reflect that, that can really assist you in the public interest. I mean, one way to do these investigations is to do them in stages. Go in and do your initial investigation, and then when you find all this out, go back and raise it with the sort of relevant owners or the relevant business. Because apart from anything else, then they can't say they weren't on notice for this. So you might raise all this, and if they say, oh, it's terrible, we'll address this, and then go back in later and see if they have addressed it. Because then if you release that and they say, well, we didn't know about this, you can say, well, yes, you did, because because we told you all about this. In terms of the practicalities, document everything. If you're going to try and get legal proceedings on the back of this, like criminal proceedings, are the people involved willing to be witnesses? Because if you do a criminal prosecution, whether you bring it yourself or you pass on this information, then obviously we have what we call disclosure. So the prosecution have to disclose to the defence all relevant material, including material that they're not relying on. And that can be who else was there, because we might want to interview them. Yes, you've shown all this, but we'd like to chat to the other people because they might have seen something that's not as bad, or we'd like to cross-examine them, and why aren't they coming and giving evidence? So that's the thing, the people who do this have to be willing to stand up, and you can't be anonymised or anything like that. And think of the potential threats and reprisals. These are all sorts of things that you need to consider. In terms of documenting, if you're filming, ideally film somewhere where you can prove the time and date that things were filmed on. I mean, some things will actually record all the metadata, but if there's any other way that you can sort of show, when it was recorded, how it was recorded, where it was recorded, all that sort of thing. Because people will come back and say, that's unreliable evidence. It's, there's nothing there to suggest when that was taken or what premises. You might want to leave cameras in place if you can get in there. You do have to be careful about sort of privacy implications as well. People can have if people have a legitimate expectation of privacy, which can be while they're at work, then they might have a civil claim against you if you identify them or show their faces, especially if they themselves aren't actually connected directly with the wrongdoing. So be prepared to pixelate people if you're publicising this yourself. If you're just referring it to the authorities, you can just hand everything over and let them deal with it. But, again, this is the thing. And even if the workers themselves aren't bothered, and bear in mind, they might be exposed to all sorts of consequences, but it might be that their bosses say, right, we will fund, a civil claim on your behalf for breach of privacy. And, people will go, because you can't get an injunction generally to stop defamation. So if you're saying this isn't true, then generally speaking, you can't get an injunction until after a trial. But if you say this is a breach of privacy, then it's a lot easier to get an injunction, because the idea is that, once the cat's out of the bag, you can't put it in again. So when it's privacy, they tend to say, right, we'll wait till the actual trial before deciding whether you can actually release all this information. And that can be years down the line and hideously expensive. I mean, litigation is expensive, and these people will throw all their resources to try and stop you. Now, the one thing with the investigation is a lot of what you'll be doing, by definition, it's covert and arguably illicit. Now, people can challenge the introduction of evidence. So let's just say that you're going down the criminal procedure route. I mean, we've covered if you release it yourself, all the defamation type aspects and breach of privacy. But let's just say you just you go down the criminal route. Well, people can object to the admissibility of evidence. It's called Section 78 of the Police and Criminal Evidence Act 1984. And that comes into play where the way the evidence was obtained is so egregious that, notwithstanding it is useful and valid evidence, it would be an affront to justice if it's admitted. Now, actually, in this country, unlike the US, where they have all that fruit of the poison tree thing, in fairness here, courts, generally speaking, will allow evidence to go in, regardless, so long as it's not obtained through sort of, torture or oppression or something. Generally speaking, they will allow it to go in, because the argument is that they shouldn't use the power to say something isn't admissible merely to punish the wrongdoing of the prosecutor, because it's in the interest of justice that trials happen, and if people have committed offences, then they are proceeded against with. So it is quite a lower burden here, but you do need to be aware of this sort of thing. Also, there's something called the Regulation of Investigatory Procedures Act. Now, that normally only applies to people like the police or the security services, or actually it's anybody charged with the investigation of offences. It's the same with PACE, the Police and Criminal Evidence Act. That applies to everybody charged with the investigation of offences. So it applies to like store detectives, for instance. But if you're doing an undercover investigation, are you charged with investigating an offence? Well, arguably, if you're just doing it off your own back, then no, you're not. You are just, citizens who have observed a crime and have reported it to the authorities. So does things like RIPA and PACE apply to you? The starting position is no, it doesn't. However, there have been cases, I can think of one case in particular, where it was a hunt stabbing type thing, but they'd brought some evidence to show about an illegal fox hunt. And this was at the magistrates' court, and they refused to admit the evidence because they said, you have obtained this evidence illegally, and the mere fact that you've handed it over to another prosecutor, I think it was the RSPCA in that case, that doesn't get you round the block. Because, say for instance, the argument is that prosecution authorities could franchise out the investigatory part of it to get round all the prohibitions and limitations that RIPA and PACE actually put in place. So I can see the logic behind it, although I think in that particular case where it was effectively a one-off. But if you were to do this regularly, say you just, you did lots of investigations and always handed things over to the relevant authorities, the argument there is, because you've got sort of a cosy relationship, the prosecutor shouldn't be allowed to admit evidence that they wouldn't be, if they'd obtained it themselves using these methods, it wouldn't be admissible. So the mere fact that they've farmed this out to a civilian organisation or an individual civilian, they shouldn't be allowed to get round that. So be very, very careful, about obtaining evidence. And all the, make sure you've got things like chains of continuity, write witness statements immediately afterwards. Also think about things like time limits. A lot of offences are what we call summary only, especially regulatory offences. They'll only be tried in the magistrates' court. And although we generally don't have a statute of limitations in this country, for summary offences, you must lay the information or request for the summons as it is now, within 6 months of the date of the offence. And if you're saying an offence is ongoing, it's like it's the first time you spotted the offence. You can't say, well, they're still doing this, so we can lay the information anytime. It's like, no, you took this evidence on a particular date showing the offences were being committed in this particular time period, therefore the 6 months starts running from that particular date. If it's a indictable offence, or what we call a summary or an either way offence, one that can be tried in the Crown Court, the time limits aren't quite as strict there. But yeah, so those are just some things like, you need to consider. Like I say, the law itself, there's a lot of it, and what I would say is seek specialist advice. There are people out there, and there are lawyers who will act pro bono. Like I say, I spend a lot of time doing pre-action reading for defamatory stuff, so people will want to put something out. Get it checked over first, because a lot of the time, just like a slight tweak of language, a word removed here or added here, or just add based on those facts, my opinion is, or I think this, so you're not making statements of fact and things like that, So, there are people out there who will assist on that. But I hope that was of some use for you. Like I say, I've only really skirted over things you need to be aware of, but when you're sort of planning one of these operations, maybe sit down and create some headings, work out what the risks are, and work out how you can mitigate those risks. And all I would say is another offence I should talk about is the 2007 Serious Crimes Act, which makes it an offence to encourage or incite somebody to commit a criminal offence. So on the back of this, I wouldn't encourage anybody to be breaking the law. This is merely information and guidance out there. It's certainly not legal advice, certainly nothing you can sue me for anyway, and I certainly wouldn't encourage anybody to actually go out there and break the law. But having said that, good luck.